Can employers legally deduct from tipped employee wages? Imagine working hard serving customers and then finding part of your tips taken away. You might wonder if that's allowed. Well, let's explore what the law says about deductions from tipped wages. First, a tipped employee is someone who earns at least $30 in tips each month. Under federal law, employers can pay tipped employees a lower direct hourly wage, as low as $2.13 per hour. This is called a tip credit system. The idea is that tips will make up the difference to reach the full minimum wage. If tips plus the direct wage do not equal at least the minimum wage, the employer must pay the employee the difference. Employers can only deduct certain costs from tips. For example, if a customer pays with a credit card, the employer can deduct a prorated share of the credit card processing fees from the tips left on that card. These fees are a cost of accepting the card, not a tip reduction. Employers can also withhold tips if the employee agrees in writing. This might be for things like health insurance premiums, union dues, or retirement plan contributions. But the employee must give written permission beforehand. Employers must give notice in writing at or before hiring if they plan to use a tip credit to meet minimum wage requirements. They cannot requiring employees to give up tips or tip out to managers or owners, except in lawful tip pooling arrangements among employees who usually receive tips. Cash tips can be held by the employer for the employee, but only if the employee agrees voluntarily. The total tips must be paid out with the employee's regular wages. On the other hand, certain deductions are not allowed. Employers cannot take tips to cover business expenses, shortages, or customer walkouts. Service charges added automatically for large parties are not tips and belong to the employer. Employers also cannot requiring employees to share tips with non-tipped workers. To stay compliant, employers need to keep accurate records of reported tips and wages paid. They must withhold taxes on wages and tips and clearly separate wages from tips on pay statements. If an employer improperly deducts from tips or wages, employees can take legal action. In short, employers can deduct some amounts from tipped wages if the employee agrees and the law allows. But they must ensure that after deductions, the employee still receives at least the minimum wage. Any unlawful deductions from tips or wages are against the law.